Lord, yesterday a matter was listed, which was left over.
Yes.
Study center, my lord, we have extremely urgent. Students are saying that they will file case against us. So,
Okay,
my lord, may kindly fix a matter on Monday, my lord.
Just.
There is a government order in our favor that the government has asked this CRT that you
Monday is a motion day, so we will have it on Tuesday.
obliged.
Lordship, I have filed an IA for implement on 28th of February 2023, and the same has already been numbered, Your Lordship. So any date, Your Lordship, in the next
30th, 30.
Lordship,
But make a mention in the morning on 30th. It's only for implement. So by the time, because these few days will be, we have no such fixed time when to rise, when not to rise. So give us the mention in the morning so that we can pass the order.
Lordship, so far item 18 and 19. I am for the 19, my lord. And 18 has been tagged with 19. My prayer, my lord, 18 is to be dealing my lord, from 19.
Okay, later matter reach, we'll pass appropriate.
Master, my friend said that 18 they will take time. 18 for they will time. So let them allow, but with delay. But my matter is to be hard today. Very my lord, urgent matter.
We are not passing any order at this stage. Okay. Yes.
I beg to mention for orders listing, only deemed to be served order is required, but it is only retired.
38, 30.
I beg to mention item number 2, my lord. Mr. H.R. Chaudhary has gone to doctor, my lord. Part of matter, my lord.
You are in part heart matter somewhere.
A part of matter.
This.
Yes.
With whom?
Item 2, my lord.
Is it a part heart matter?
Oh, yes, part of matter.
You want to do it today?
No, my lord. Mr. H.R. Chaudhary has gone to doctor, my lord. At 10:30 appointment, my lord. And may not come in timely, my lord.
You be here, will not take up, but will pass the appropriate order.
Yes. Okay.
Mr. President, I beg to mention item number 12 on behalf of Mr. PJ Pokone. He is on leave, your lordship. Consent has been taken, your lordship.
Have you informed the other side?
Yes, your lordship.
On 4th.
Yes,
4th of April.
May I please, your lordship? Lordship, I beg to mention item number 20, lordship.
Yes.
Lordship, kindly the matter may be adjourned for the day, lordship.
Yes.
Obliged, lordship.
Yes,
May I please, your lordship? Lordship, I beg to mention for listing up a matter. The matter may come up next week on any convenient date.
It's for order or for admission?
Yes, lordship, for orders column.
30th, 30.
30th? Deeply obliged.
Item number 18 also, he
We'll take up together, then we'll pass the order.
item 1 or
We have already given that approval for appointment of the petitioner lordship. The director issued a letter to the inspector of school for regarding appointment of the petitioner lordship. That approval has already been given. ওলাই গুচি গ'ল।
This contempt petition is against is for non-compliance of the order dated judgment and order dated 0809/2022. First date WPC number 6038/2000. Mr. A.H. Ahmad Chaudhary, counsel for the petitioner, and Mr. S.M.T. Assistant Counsel, Department of Education. Though petitioner was selected by the school selection committee only. During the deliberation of the matter, the Director of Secondary Education Assam, by communication number ZB-DSC/DSC/CC/3/2022/48 dated 22/03/2023 apprised the court that after obtaining approval from the government in the secondary education department by letter number E-270148 dated 04/02/2023 the recommendation of the school selection committee dated 04/04/2018 recommending the petitioner Srimati Nazifa Sahani Borbia for appointment to the post of graduate postgraduate PGT capital in botany of Adhar Chand Higher Secondary School, Silchar, District Kachar has been approved. By received communication 22/03/2023, Director of Secondary Education Assam directed the Inspector of Schools, Kachar District Circle, Kachar, to take necessary steps regarding appointment of the petitioner to the said post of PGT Botany in the said higher secondary school. In view of the above, as the responding authorities have complied with the judgment and order, there is no such contempt on the part of the respondent complainants. Accordingly, it is stated. Copy of the communication dated 22/03/2023 of the Director of Secondary Education Assam, but yes, Assam noted about the captain.
Obliged.
Yes, Mr. Saikya.
Your Lordship. In this case, the petitioner, if your Lordship, was working as in-charge principal of the school, my lord. My lord, for treatment, my lord, she had to go to Chennai. But by informing the authority, my lord, she went to Chennai, my lord. But after coming from Chennai, the implementing order at page 36 has been passed by the inspector of schools, my lord. Page 36, my lord. He has removed me from the post of in-charge principal, though he cannot do that, my lord. And my pay has been held up. I have been held to be unauthorizedly absent. Page 36, my lord. Thereafter, my lord, by another order at page 44,
Just a minute. Page 44.
44, my lord.
Yes.
The private respondent has been appointed as the in-charge principal of the school.
Yes.
Well, in the interest of public service, until further order, Srimati Gitasri Das, MA B.Ed, subject teacher of Sonu Lakshmi Higher Secondary School, District Kasar, is hereby allowed to hold the charge of principal of the same school.
Yes. Then what happened?
Well, already the degree of B.Ed degree of the private respondent has been held to be invalid by the authority itself, well, at page 64. Page 64, my lord. Last paragraph, my lord. Order.
Yes.
How can a person without having a valid B.Ed degree, my lord, can be appointed as in-charge principal of the school, my lord? And my lord, I have been removed illegally, as the lordship has seen at the impugn order passed by the inspector of schools at page 36. And my appointment order as in-charge principal has not been recalled by any of the order, my lord, by the director. The inspector of schools cannot recall a order passed by the director, my lord. And I have not been paid my salary since December till today, my lord. So, my lord, both the impugn orders may be stayed by this honorable court, my lord. I am without salary since last 3 months, my lord. 4 months.
What, Mr. I take counsel appearing for the petition. And Mr. P. Kaushik, standing counsel, Department of School Education, for the respondent number 103. Mr. Alex, standing counsel, NCT, for the respondent number. You are subject teacher of which subject?
I am subject teacher of English, my lord.
Petitioner is a postgraduate teacher.
Economics, I am sorry, my lord, economics.
Economics. Since April 1992. In Swarnalakshmi Higher Secondary School, Narsingpur, District Pachar, the provincialized higher secondary school of the state. She obtained her BRE examination from Government Institute by an order dated 22/01/2020. The Director of Secondary Education Assam allowed her to be the principal in charge of the said spot from Korea, along with financial power, draw and disburse salary, etc. of the staff of the said school, in addition to her normal duties as subject teacher under FR 49C. While she had to rush to Apollo Hospital at Chennai, Tamil Nadu for her treatment. The Inspector of Schools, Kachar District Circle, Kachar, by an order dated 20/12/2022, removed her from the principal in charge of Kachan Chachar School, with a direction to cut her pay of salary for 19 days, effect from 02/12/2022, 2012/2022, and also to suspend her salary from the month of December 2022 until further order. The observation that the selection of new drawing and disbursing officer of the said school shall be taken up for consideration by the Director of Secondary Education after taking further necessary action. By an order subsequently, the Director of Secondary Education Assam, by an order dated 30/01/2023, allowed the respondent number 5 another subject teacher of the said higher secondary school to be the in-charge principal, to be its in-charge principal, granting her financial power to draw and disburse the salary of the staff of the said school, in addition to her normal duties as subject teacher under FR 49C, as the petitioner has been relieved from the said charge of principal for the said school. by placing a communication of the Commissioner Secretary to the Government of Assam in the Secondary Education Department under number ASC 73/2020/COPC at the rate of 678 COPC within the C civil 678/2019/23 dated 24/01/2020 apprised that the B.Ed degree obtained by the respondent number 5 from Dr. S.B. Institute of Education, Hailakandi is not a valid B.Ed degree approved by the NCT. Mr. Saikia, current counsel appearing for the petitioner submitted that it is a settled position of law that any person who is to hold the charge of headmaster / principal of any secondary school of the state must have the requisite eligibility for the said post. Since the post of principal in any higher secondary school is required to be not only a master degree but also to be a B.Ed from a valid institution, and as the respondent number 5 doesn't have the said qualification, it's not eligible to hold the said post. Mr. Saikia further placed before the court that the Assam Secondary Education for 2018 rules are right. Here. Though petitioner is serving, Mr. Saikia, though petitioner is serving in the same school, she has not been paid her salary since December 2020. Are there any disciplinary proceeding initiated against you?
No, my lord. One enquiry is directed at page 45.
Mr. Vikram? Can't you wait?
But with regard to the order at page 36, my lord,
So notice returnable by until further order before. As the respondent number 5 doesn't have the requisite eligibility, having a B.Ed degree from recognized NCT, it shall remain suspended, and the inspector of school, Patra district or Patra, shall be allowed to do the
obliged.
till a regular, till another teacher is having valid B.Ed degree on to be eligible to hold the post of such and such a state higher secondary school on the basis of security.
Obliged.
The petitioner shall be paid her salary as per her entity after her joining in service. And say such and such.
On 20th, I joined. My lord.
Where is
20th,
your joining date?
my lord, I have stated page 26, my lord, I'm sorry.
Where is your joining report?
Page 26, my lord.
26 is not your joining date.
Page 26. Is 8, my lord, paragraph 8, my lord. I have stated.
With effect from 21st of December 2022. Until further. For the period from the shall be paid her salary for the period from 1st of December to
On 20th, I joined. 2nd, I left, my lord.
you were on leave again when?
My lord, on 2nd, I left for Chennai, my lord. I joined on 28th. So, my lord, I was on leave, my lord, from
On-
2nd
from-
to 19th.
For a period from 1st December and from 21st of December onwards. If she is found to be serving India, regularly serving. Was there in the other side? Respondent will LDB. Then if you- PCDS. लिखा नाले order to pass करो. The matter was heard yesterday. Heard MS Mr. SMPC standing counsel secretary. Mrs. Antipas, standing counsel department of school education. The respondent numbers. One, two, and 4. Also heard Madam of the prominent Pedasa for the respondent number 3 and Mr. E.C. Day, Senate Council for the respondent number 6. It is contended by the petition that though he is serving since 1/1/1996 in Milanjoti ME Madrasa in the Rongia Education Block, Kamrup district since its cancer stage. But due to wrongly placing of the documents in favor of the respondent number 6, who happens to be the son of the president of the school managing committee of the St. Church. The district scrutiny committee, without considering his eligibility and seniority, recommended the name of the respondent number 6 for provincialization, who was not in service since 2020. That's it. in the service in the same madrasa till 2017. The petitioner has also placed before the court that the respondent authority in the elementary education department of the state, including the state selection committee, state level selection committee, without any such verification, granted its approval for a provincialization of service of the respondent number 6 under the provision of the 2017 Act without verifying any records. Being agreed, petitioner has filed its. On the other hand, Mr. De Learned Counsel for the respondent number 6 submitted that he is serving in the same school since 0301 1/1/2021, and his name is duly recorded in the DICE data for the year 2016-17. It is also placed on behalf of the respondent number 6 that all the teachers of the said ME Madrasa used to teach all subjects to its students, and therefore the respondent authorities rightly considered his case for provincialization and accordingly provincialized his service as a tutor for provincialized his service, and the Director of Elementary Education Assam, by its order dated 0502/2020-21, provincialized his service as a tutor under the said 2017 Act with effect from 01/01/2021, and attached him in the base school, namely Hiragata Lower Primary School in the district of Kamrup under the Block Elementary Education Officer, Rongia. Pursuant to the order report dated 07/06/2022, the petitioner has implicated the headmaster of Hirabat LP School as party respondent number 7 present person. During the deliberation of the matter, Ms. Devi Learned Counsel for the petitioner brought to the notice of the court that the Dean and Director of Elementary Education Assam by its communication number EPD.41/2013/132 dated 20/01/2016 to consider Rekibuddin Ahmed and the petitioner as headmaster and assistant teacher of Milyon Jyoti ME Madrasa under Rongia Educational Block specifying the list of other teachers, including head teacher, a Hindi teacher, science teacher, art teacher, and grade 4 of the said madrasa, stating further that the district level scrutiny committee had recommended with resolution in its meeting held on 17/10/2025 for modification in respect of headmaster and assistant teacher with proper justification. And that said Milyon Jyoti ME Madrasa recognized on 01/01/2005 under the Rongia Educational Block, for which particulars have already been submitted to the government for provincialization of services of teaching and non-teaching staff by the letter of the Director of Elementary Education Assam under number EPD.99/2013/PT/14 dated 13/07/2014. By placing the said communication of the DE Assam dated 20/01/2016, the petitioner placed before the court that is said letter doesn't contain the name of the respondent number 6. Even in 2015 and 2016. For provincialization of the services during the 2011 program in the course well this 2011 it was in force. In this aspect, no notice in this case was issued on 01/04/2021. Neither the respondents in the elementary education department, the district scrutiny committee, Rongia, Kamrup, district scrutiny committee, Kamrup, and the private respondent number 6 could place anything against this letter of the Director of Elementary Education Assam dated 20/01/2016. noted. So the Learned Council for the respondent department submitted that the petitioner has disputed the facts regarding the serving of the respondent number 6 since such and such the non-availability in the school even in 2016. As such disputed facts cannot be entertained in a writ petition. This documented evidence of the letter pertaining to Director of Elementary Education Assam dated 20/01/2016 as well as letter dated 13/07/2014 mentioned in the said letter dated 20/01/2016 remain unobjected at any point. Section 14. Highlighted. Until further, in the event of filing such and such statement. Even the letter of the DE Assam, such and such for APT 41/2018-132, APT 99/2013. Petitioner shall be given the effect benefit. It is found that it is considered for such effect. Removing the respondent number 6. Mr. Saikia,
Lordship.
we've been doing lots of this provincialization cases. But very sorry affair. Neither the district scrutiny committee nor the state level scrutiny committee really have gone through the process, though it was very much there in the act.
Procedure.
They have not followed. In Mr. Sistil Beer, there are numbers of schools which have been provincialized. It's a mixed medium school or it's a girls' semi school. No washroom, no toilet, no water facility. Now, if it's a ME school, it is up to class 8, as you know. The girls will attend puberty. That day, the departmental secretary was there.
Lordship.
Mr. Sisti himself had brought it to the notice of the secretary. Provincialized for whom? For the students or for the particular employee? Who will be benefited?
Here, the focus is on the teachers. It is not students and.
And what is very surprising, you see, you have allowed, not Mr. Saika, what the department was the, to the act. At the public expenses, you have allowed the teachers who are illegally appointed or somebody to obtain their master degree, to obtain their PhD, to obtain their MPhil, whatever is required. At the public expense, how come? That was not the policy earlier. Earlier it was there, you obtain it, then in your consideration will be there. Why at the public expense? For a college lecturer, you are paying 25,000. For a school teacher, you are paying 15,000. Although they are not eligible at all. You should have asked them to obtain the eligibility at their cost. Then to consider for provincialization at that point of time, to take place in 5 years. At the public cost, you are doing it. The act provides. Very surprisingly, you know, these things happening. Mr. Sisti is fully aware. He has seen the records.
I'll discuss, Lordship. And I will
This is very
Yes,
issue
Lord.
because
We'll do something.
if a mixed medium school doesn't have a washroom, if a girls' semi school doesn't have a washroom, being provincialized.
Lordship will look.
That day, of course, you are not there. Most possibly, you are not available at state. That's why Mr. Sisti appeared for the secretary. He was brought to notice of all these things. Yes, let us see here.
This advertisement was issued for a post of principal that your lordship will find at page 20. One post. Kokrajhar Government College.
Yes.
And page 23 is a selection procedure will be notified later on, followed by issuing corrigendum and a addendum if required. Page 23.
Yes.
Now, page, my lord, your lordship, can you see page paragraph 6? Interview appeared, interview happened on 5/11/22.
Where you are saying?
My lord, para 6, your lordship, can you see?
There are 6 of your.
Petition.
Yes.
That the petitioner respectfully states that thereafter the petitioner appeared in the interview on 5/11/22, and she found that the interview board has been constituted by the following members: chairman, 5 members, 3 expert members, Dr. So-and-so, Dr. Rishikesh Borua, Dr. Jotin Sharma. There is no ST member because both the members were ST. That is required under the UGC regulation. That I will bring. My lord, your lordship will note the fact that 3 expert members are there and the expert members, nobody is ST. That your lordship has also noted while passing the interim order. I'll come to the regulation later on, and the results were declared on the same day, 5/11/22. That your lordship will find at page 51. Same date, interview, same date, results declared.
Yes.
Now, your lordship, can you see that affidavit in reply filed by us? Affidavit in reply filed by us, that is at page, because there the whole regulation has been annexed. That is at page, my lord, 91 onwards. Now, 102 is the UGC regulation 18/7/18. The lordship, can you see page
104.
104? I'm just showing the college principal and professor. They are of the same category. Then page 111. This is regarding the qualification. The research score, my lord, government has given a notification that research score is not required. I'll show that, my lord. That is dispensed to it. Research guidance. Then page 117. For the 115. Man. Selection procedure. May I read, my lord?
Just a minute.
6.0.
Yes, please.
Yes, I'll just read this. The overall selection procedure shall incorporate transparent, objective, and credibility method of analysis of the merits and credentials of the applicants based on the weightage given to the performance of the candidates in different relevant parameters and her performance on grading system pro forma based on appendix so and so on. In order to make the system more credible, universities may assess the ability for teaching and or research aptitude through a seminar or lecture in a classroom situation or discussion on the capacity to use the latest technology in teaching and research at the interview stage. This procedure can be followed for both the direct and recruitment and the CAS promotions wherever selection committees are prescribed in this regulation. The universities shall adopt these regulations for selection committees and selection procedure through their respective statutory bodies, incorporated appendix so and so at the institutional level for university departments and their constituent colleges affiliated. Now, your lordship may skip, come to 3, Roman 3. In all the selection committees of direct recruitment of teachers and other academic staff in universities and colleges provided herein, an academician belonging to the scheduled caste, scheduled tribe, OBC, minority, women, differently able categories, if any of the candidates belonging to this category is the applicant, and if any of the members of the selection committee does not belong to that category, shall be nominated by the Vice Chancellor of the university. And in case of a college, Vice Chancellor of the university to which the college is affiliated to, the academician so nominated for this purpose shall be one level above the cadre level of the applicant, and such nominees shall ensure that the norms of the central government or the concerned state government in relation to the categories mentioned above are strictly followed during the selection process. So in this case, my lord, the expert committee, my lord, expert member, none of the expert members belong to a civil tribes community, as the petitioner belongs to that category. On this ground itself, my lord, the selection procedure is liable to be set aside in quash. I'll show the, my lord, now page 119, your lordship will kindly see, 117, 117. Assessment criteria and methodology.
6.1.
6.1.
Yes, please proceed.
Table 1 to 3 of appendix 2 are applicable to the selection of assistant professor, associate professors, professors, which is equivalent to principal, my lord, senior professors in universities and colleges. So appendix 1, your lordship will kindly see page 121, table 1. These are the criteria. None of the criteria has been followed, as has been reflected by them in their affidavit in opposition, APSC. Table 1, record is there. I have seen the record, Major. As your lordship, just the method I am showing. Table 2 is at page 122. Table 2, your lordship is in. Table 3, your lordship can see at page 124, my lord. Criteria for shortlisting of candidates for interview for the post of professors in universities. That this is also applicable for professors. And table 3B, At page 125, score, my lord, academic score 80, research for publication 10, this has been dispensed with, teaching experience 10, 100.
Page
Table-
120, you are talking
Page
about
125,
that 80, 10 and 10.
yes. And table 3B, my lord, it is not that somebody will come and sit for the interview for 10 minutes and the results will be declared on the same day. It speaks many things, my lord. 3B, my lord. Page 125. Criteria for shortlisting, which is all these, my lord, marks in graduation, post-graduation, NET, PhD, all these marks are there. And ultimately, page 126, academic score, research publication 6, teaching experience 10, total 100.
No, but it speaks about only table 1 to 3, not about 4.
1 to 3 only. This is I'm 3 only, my lord. Page 126 top is continuation of 3.
3A.
3A, my lord. 3B.
3B.
So this is the position, my lord, and your lordship will kindly see APSC's, my lord, affidavit.
Yes.
First, they say writ petition is not maintainable. Paragraph 2. Unsuccessful candidate cannot participate in selection process. Then paragraph 3, my lord, it says pursuant to Government of Higher Education Department's requisition, APC has published the advertisement. And paragraph 4, they say, my lord, the requirement of research guidelines has been dispensed with as per the government's notification. Paragraph 4, my lord, that your lordship will find page 14 of the affidavit. In inviting page 14 of the, that is inner page marking is not with me, my lord. Page 14 of the affidavit filed by the APSC.
4 or paragraph 4?
Now, paragraph 4, your lordship will kindly see page 14.
Internal place 14?
Yes.
Yes.
In inviting a reference to a letter on the subject cited above, I am directed to request to kindly to follow the government OM dated 19 regarding educational qualification for recruitment to the post of principal. Kokrajhar Government College, Kokrajhar, as government has yet to issue a new guidelines inserting qualification research guidelines for recruitment of the post of principal of the government college. Now, but they said this it has been dispensed with. But I am not there. Paragraph 4 may kindly be read, my lord.
Yes.
The educational qualification as mentioned under clause so and so, the requirement of research guidelines, guidance as necessary qualification has been dispensed with for applying to the post of principal Kokrajhar Government College. In the said letter dated so and so, it is stipulated criteria of educational qualification should be as per government OM dated so and so. Now, paragraph 6, your lordship, can you see? The deponent begs to state that for selection of principal Kokrajhar Government College, a multi-member interview board selection committee has been constituted under the provisions of Assam APSC procedure 2019, headed by the chairman APSC as its chairman. The members of the selection committee are Bharat so IS retired. Number 2, Dr. Ajanda Ajanta Nath, member APSC, Dr. Niranjan Kolita, member APSC, Srimati Julie Sonwal, member APSC, Sri Ghanakanta Pegu, ACS, retired, all these are retired members. Dr. Padma Sharma, member APSC, Dr. Manoj Mohanto, they looks like expert member, principal, Pragjudis College, Dr. Rishikesh Barua, principal, KC College, Jotin Sharma, head of Department Biotechnology, Boroland University. It is to be mentioned herein that out of the aforesaid members, Srimati Julie Sonwal, IAS retired, and Sri Ghanakanta Pegu, ACS retired, belong to scheduled tribe category, and 3 experts, namely Manoj Mohanto, Dr. Borua, and Dr. Sharma, were nominated by the Government of Assam, Department of Higher Education. So admittedly, there is no tribal experts as per the regulations. Now they say paragraph 7 that deponent begs to state that the selection committee, after assessing the respective merits of both the candidates as prescribed under the regulations, under the UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges, and measures for the maintenance of standards in higher education department 2018, in short UGC regulation 2018, as well as the guidelines office memorandum issued by the Higher Education Department, Government of Assam, has selected and recommended name of Dimasa Doing Misuari for the post of principal. Then now your lordship may skip paragraph 11 may kindly see that with regard to amendment made in paragraph 6, the deponent has denied the same as a whole. The deponent has categorically denied that respondent APSC has wrongly incorporated Dr. Manoj Kumar Mohanto and Rishikesh Barua as expert members in the interview board. It is also denied that academic statements of scores were not placed before the members at the time of interview, and no research paper publications were verified in the interview. In this regard, the deponent begs to state that the expert members were inducted in the interview board as per the nomination from the Government of Assam Higher Education Department. Further, the commission, considering the professional expertise, requested Dr. Manoj Kumar Mohanto, Dr. H. Borua to prepare academic statements of the candidate to the post of principal, Kokrajhar College. This cannot be a ground for debarring them from performing the role of expert. Now, with regard to the allegation that the interview has been conducted in a biased and determined manner, I'm not going to that. Let me read, referring to the API marks, that is all right. I have seen 110 is good enough for both the things. That I am not coming there. So, paragraph 12, my lord. Mark plugin display. Paragraph 11, Malad, I am continuing, Malad. Second paragraph, with regard to allegation that the interview has been conducted in a biased and determined manner without referring the qualification API score of the petitioner, deponent has denied the same and begs to state that the interview process consisted of 2 parts: marks against academics and experience, as well as performance in the interview. The marking pattern consists of total 100 marks, out of which 20 marks for academic, 5 marks for teaching experience, 5 marks research and publishing, 10 marks for administration, 10 marks against communications ability, 5 marks for ability to plan institutional program, 5 marks against ability to analysis and discusses curriculum development, 5 marks for ability to analysis and discuss research support, 5 marks for ability to analysis and discuss development, 10 marks against ability to deliver lectures program, and 20 marks against interview performance. As such, contention of the petitioner is most concept. If we look into the marking pattern, we find, my lord, 40 marks and 60 marks. 60 marks all interview, and 40 marks has been given on the basis of teaching experience, marks for research, 10 marks for administration, 20 marks for academics. These are the analysis which we have found. Rest, my lord, against communication ability, these are all interview based marks. 60% it comes to. Now, paragraph 12, my lord, the respondent authorities have conducted the entire procedure for selection in a predetermined and hurried manner only to favor respondent mercy, which has been denied in this regard. Deponent Baxter said the entire interview process was conducted in a just and transparent manner. All norms were followed, letter and spirit. So they have shown the marks, how they have given the marks, and marks is on the basis of the, my lord, interview process and the marks allotted in the marks which the candidate got in the academic, in their respective academic. Now, your lordship will kindly see, I'll just show one that APSC, my lord, 2021, the regulation, 4 Act.
Has it been annexed?
No, it's regulation.
Do you have an extra copy?
I'm giving.
It is in the website.
It is in the website.
It has come into force when?
It is coming to force. Huh? Huh? December 22. 21.
Interesting.
It is. 21. December 21.
Okay. This is still in
But-
force.
Yes, it is in force, I think, madam. But I think, my lord, this advertisement was issued on 3/11/21. So
Whether this was acted upon or not, we do not
it
know.
was
That
not
is,
acted.
is there anything in the
2019.
record? You have checked the record. Is there anything in the record?
2019, I think they have acted.
Then this may not be applicable.
This may not be. My lord, your lordship will kindly see this on 2 points. The violations of the UGC
One is that
regulation.
the selection
Expert
committee didn't
committee.
had the scheduled tribe candidates.
Yes.
That is one. And second, the same day marks has declared, results has been declared.
No, third, my lord, that as per UGC regulation, marks has not been given. Your
So
lordship
as
will
per
see
the that tables 1, 2, 3,
Yeah,
the marks have not been
marks has
distributed
not
in
been
favor of the petition.
On that, my lord, I will show one judgment. And BTC, my lord, they have said, my lord, this is not maintainable because candidates have not been appointed, and since you have said, you have set in the selection process, so you now you cannot question. So this is what the BTC says. There, I will give question. My lord, your lordship will kindly see. Like, on monastery, like. 2015 5 GLR 56. Para 12, my lord. Very good.
Yes.
In the instant case, the functions of the selection committee for selection of assistant professor in a government college has apparently been entrusted to the APSC and not to the teachers recruitment board. If the selection for the post of assistant professor in a government college is to be made by the APSC, what should be the compositions of the selection committee? As already noticed under clause 5 of the APSC is required to invite 3 expert subject experts from which the concerned university be involved in selection process. Though the clause is not happily drafted, in my judgment, it can only mean that 3 subject experts from the concerned university should be invited in the selection process. This was not done by the APSC in the interim selection process, since according to the APSC, it has its own mechanism for constitutions of the selection committee, as provided for in Rule 21 of the APSC rules and is therefore not required to follow the UGC regulation. The chairman of the APSC accordingly constituted the board for interview comprising of one member of APSC and one expert committee deputed by the government for conducting the interview. At this stage, it may be apposite to refer to the clause so and so of the APSC rules. The chairperson shall constitute board for interview. However, states the single member or multi-member board may be constituted taking into consideration the grade, status, and importance of the post, respect of which the selection is to be made. My lord, 12A, reading of UGC regulations and the APSC rules extracted in the foregoing in juxtaposition unmistakably indicates some evidence of conflict between the two sets of provisions with respect to the compositions of the selection committee for the post of assistant professor in a government college. The question to be considered now is which of the two sets of provisions shall prevail. The rule of construction is that even where there are in two enactments, two provisions which cannot be reconciled with each other, they should be interpreted in such a manner that if possible effect should be given to both. Thus, a construction that reduces one of the provisions to a useless lumber or dead letter is not harmonious construction. To harmonize is not to destroy. In so and so, the Apex Code permits the principles of making cross-reference to such sections of two enactments to read them harmoniously. This is what it reads. One of the methods adopted in such situation is to make the cross-reference to the relevant sections to read them harmoniously. Thus, way back in Ram Kishan Dhanuka's case, the Privy Council was faced with such a situation in a case arising under the Companies Act 1913. One of the articles of association, Article 109 of the company concerned, prescribed a maximum of 4 and minimum of 3 directors without any qualifying words. Another article, Article 126, authorized the company in a general meeting from time to time to increase or reduce the number of directors subject to the provisions of Section 83A and to alter their qualifications and change the order of rotations of the increased or reduced number. Malad, your lordship may state this. Para 13, your lordship. Yes. Para 13. I am not unmindful of the fact that the APC is a high constitutional body constituted under 315 of the Constitution, has a distinct status under the Constitution apart from the government of the state and cannot be identified with such government. It is undoubtedly an important institution to whom it is entrusted a valuable and important task of selecting personnel who may be entrusted with the duty of running the administration. Thus, the administrations, or so to say, the destiny of the people in the state depends very much on the fair and just decisions of the Commission. The power conferred on the APSC must be deemed to necessarily carry with it the power to regulate the manner in which the Commission should discharge its function. The APSC rule is obviously framed by it to regulate the manner in which it should carry out its business. As regard as already noticed under Rule 21 of the APSC rules, the manner in which the board for interview viva voce is to be constituted for selections of various posts by direct recruitment is provided for, which evidently comes into conflict with the provisions of UGC regulations. It must be noted that in the matter of selections of assistant professor in a college, the association of 3 experts from the concerned university in the board for interview viva voce was constituted by the APSC as stipulated by the UGC in clause so and so cannot be ignored by the APSC, so that the minimum standard of teaching prescribed by the UGC is maintained at all. On the other hand, the power of the APSC to regulate the manner in which its business should also be ignored, cannot be ignored, I think. In my judgment, this conflict can be harmonized and resolved by resorting to the principle of making cross-reference to the two sections as pronounced in so and so case, we can so that we can imply in rule 21 of the APSC rules the word subject to clause so and so of the UGC regulations insofar as recruitment to the post of assistant professor in government college is concerned, so that effect can be given to both the provisions of the APSC rules and the UGC regulation. Now, paragraph, my lord, next paragraph, my lord, in the middle portions. My lord, in the middle portions,
Of para
after
13 or 14.
para 13, my lord.
Yes, please read. That's what we did.
Para 14, my lord, sorry. Para 14, after about 7 lines, APSC, as your lordship got in. APSC rules hereby, thereby completely ignoring the selection procedure.
You got it.
Selection procedure prescribed in the UGC regulations. This will render the UGC regulations nugatory.
Yes, what we have seen that here
So therefore,
the UGC regulation was prevailed over the APSC process of
yes,
selection.
paragraph 17, my lord. Yeah, may I continue reading, my lord? Same paragraph 14, my lord, after that last lines, last lines, my lord. So constitute, it becomes obvious that the service rules referred to in clause 19 of the APSC rules cannot but be the UGC regulations in the case of selection for the post of assistant professor. Is your lordship got it? Paragraph 14, paragraph 15, last sentence. May I read, ma'am?
Please.
Paragraph 15, last sentence. So constitute, it becomes obvious that the service rules referred to in clause 19 of the APSC rules cannot but be the UGC regulations in the case of selection for the post of assistant professor of a government college affiliated to UGC. Consequently, the APSC, while constituting the board for interview, viva voice for assistant professor of a government college affiliated to UGC, is under clause 5 point so and so of the regulation required to invite 3 experts of the concerned university for the selection process. Needless to say, this will be in addition to and not in derogation of the power of the chairman of the APSC to constitute a board in accordance with clause 21 of the regulations. In this way, effect can be given to both the provisions of clause 5 point so and so of the UGC regulations as well as 19 and 21 of the APSC rules. Now, second paragraph, the provisions of the UGC Act are binding on all universities. My lord, while quoting that,
Annamalai University.
yes, my lord. The provisions of UGC Act are binding on all universities, whether conventional or open. These powers are very broad. The regulations framed by it in terms of clause E, F, G, and H of subsection 1 of section 26 are of wide amplitude. They apply equally to open universities as well as also to formal conventional universities. In the matter of higher education, it is necessary to maintain minimum standards of instructions are required to be defined by UGC. The standards and coordinations of work or facilities in universities must be maintained, and for that purpose required to be regulated. The powers of UGC under section 26 are very broad in nature. Subordinate legislation, as is well known, when validity made becomes part of the Act. We have noticed herein before that the functions of UGC are all pervasive in respect of the matters specified in clause D of subsection 1 of section 12A and clause A and C of subsection 2 thereof. In the instant case, the APSC, in not inviting 3 experts from the Guwahati University while interviewing the candidates, including the petitioner for the post of assistant professor of Pokrajhar Government College, has contravened the provisions of clause 5.1.4 of the UGC regulations and has committed illegality in the impugn selection process. The selections of private respondent for the post of assistant professor of college is therefore dehorsed the regulations and is therefore not sustainable in law. It is, however, contended by so-and-so counsel for the respondent that once the petitioner has already participated in the selection
have seen
process,
that,
that your lordship has seen. Now, paragraph 17 is also important. This matter ends, my lord, it was last sentence is, my lord, the impugn selection, paragraph 17. My lord, the
Was
whole
the
paragraph
selection
is-
process.
Yes, the impugn selection is therefore liable to be quashed for this reason alone. In this view of the matter, it is not necessary for me to examine the other contentions of the non-senior counsel for the petitioner for the simple reason that courts do not decide more than what is necessary. This is how a matter, my lord, another case law your lordship will can be seen in the process of selection of a vice principal, where the both the court below, my lord, dismissed the petitions, but the apex court has, I'm giving the printed format. जी. Here, my lord, the vice chancellor was selected without following the UGC regulations. Both the single judge and division bench, my lord, dismissed the writ petition. Supreme Court held that not following UGC regulation, it is the rehearsed regulation, therefore set aside both the judgment passed by the single judge and the division bench. That your lordship will kindly see.
Read this judgment, somewhere later part of this was observed.
The para 18, these are the facts, my lord, paragraph 2.
No, the prevail over the UGC regulation.
Yes, paragraph 18, I think. Short question which is posed for consideration of this court is,
No, there has to be a panel and only one name was recommended. It doesn't have a panel. That was, I think, so that was the decision.
yes,
And accordingly, the UGC said it has to be a panel.
yes,
And I beg to, I should have gone through that judgment earlier.
Yes.
So this, only one name was forwarded instead of panel.
yes,
That's why it is in violation of the UGC regulation.
my lord.
Probably that was the reason
Yes,
why the vice chancellor was not appointed, right?
And court says, well, Supreme Court says, well, a single judge.
UGC rules and regulations will prevail.
So these are the two things, my lord. And you will see there, my lord, marks awarded by the thing. By
But
the
can you
APC.
entertain the marks?
No, no, I'm not blowing into it, only the pattern.
Because we are not the expert body.
No, no,
Because
I'm not showing. That is, what I'm showing is that is not as per the UGC regulation. Your lordship will not go.
only
into
thing
way.
that you are saying that the distribution of marks.
Is
given
not
to the
as per the UGC regulation and they're not calling the expert body. My lord, no, my lord, one tribal members of the as expert body, that is also in violation of the.
No, that is one first
So on that
ground.
ground itself, it is liable to set aside.
That what is
And
consist
the
of this
UGC regulation.
justice
and one
bypass
day
judgment.
Principal of a college man on 5/11 you conduct the examination and same day you return. That speaks many things, man. On maintainability, if your lordship wants to see that first case I have shown, they are already discussed. Other two cases, if your lordship 2019, 20 SCC 17. Other case. Huh? Come on. Giri. 15 में. Motu could do it.
This is with regard to maintainability.
Maintainability. Two cases I am giving, another is, mother, I don't have this.
No
Paragraph
maintainability in the sense because the petitioner at the time of after the interview did not protest with regard to the selection
How
committee.
can I protest, my lord? I don't know anything. That has been discussed in that Banashri Gogol's case also.
That is there.
So another case I'm showing, my lord, 2022, 8 SCC. Para 30, para 32 will do it. And 2019 is paragraph 15 to 19. 2019, 20 SCC.
Yeah,
Para 15 to 19,
that is in 2019.
19, 20 SCC.
What about 22?
22 is para 32 will do it. Right? This will do. So on this basis, my lord, the selection process is liable to be set aside, and the best selection should be held on the basis of the candidates available as per the UGC regulation. Marking pattern, if your lordship sees, 40% given for thing, all the qualifications and all 60% on the basis of interview. DPO.
I am representing Lordship BTC as well as the higher education, and we have very limited role to play. In fact, no role at all. Whatever argument the other side is making, Lordship, from the petitioner's side, I think my learned friend, Lordship, he will be able to counter those grounds because he is representing APSC. So only thing is that our college is without a regular principal for quite long time, Lordship. So there is some urgency on our part. That is why we requested APSC to do this exercise as quickly as possible. However, subsequently, Lordship, once we have completed it, Lordship, then the other side moved before this honorable court and was successful in getting a stay order regarding the appointment. One thing I'd like to point out is that, Lordship, this UGC regulations, number one, it has not been adopted in the state of Assam till date. That is why it is not directly applicable, but the spirit is always followed regarding marking systems for various posts while doing any recruitment process, Lordship. But very interestingly, in this regulation of 2010, the marking system for the principal is not there. So it is a gray area in the regulation itself. And that is an admitted position. And we are governed by this state rules, Lordship, of the Assam Education Service Rules 1982, where there are specific provisions under Rule 6 for direct recruitment, etc. So this is to be followed. And regarding the composition of the selection board, my learned friend will counter regarding the marks which was given also. One thing that they have already abandoned one of the ground of challenge, that is he was unhappy with the API marking. That is that he has given up. So basically there is nothing survives because the committee also, I am told, Lordship, it is considered as per the requirement, Lordship. So this is my only humble submission that as soon as possible, Lordship will allow us to fill up the post of principal in this particular college. Otherwise, public interest is suffering, the students are suffering, and no development activities is going on. And the writ petitioner is enjoying the stay order because he is holding the in charge post there. The delay is helping the writ petitioner. So I am appraising all these facts before this honorable court, and my friend will continue, Lordship. I am deeply obliged.
Mayor Lord.
You have heard both Mr. Das and Mr. Singh.
Lordship.
Now tell us, you have followed a selection procedure of your own or anything that was prescribed by the government or the UDC regulation 2008?
Lordship, where there is a specific provision in the UDC regulation, we follow that UDC regulation. And in absence of any,
Just a minute.
here in this case, Lordship, the post of principal of a government college is covered by Assam Education Service Rule 1982, Lordship. As per 1982, the principal of a government degree college is a class 1 cadre, Lordship. And Rule 5 has been prescribed as a method of recruitment. Lordship, get it page 698.
Yes, yes. Yes.
Lordship, Rule 5, the method of recruitment. Lordship, got it? Page 702. The recruitment to the service shall be made in the manner prescribed hereinafter. Recruitment to the post of Director of Public Instruction, Principal of State Institute of Education, Principal Government Degree College, Lordship. So and so shall be made by the direct recruitment only with qualification prescribing so and so. Lordship, now Rule 6, Lordship, direct recruitment. The direct recruitment to the post mentioned in Sub Rule 1 of Rule 5 shall be made by the government on the basis of recommendation made by the Commission in accordance with the procedure hereinafter provided. Before the end of each year, the government shall make an assessment regarding the likely number of vacancies to be filled up by the direct recruitment during the next year and shall intimate the same to the Commission, together with the detail about the reservation of candidates belonging to the scheduled caste and scheduled tribe on any other category as provided under Rule 15. The government shall simultaneously request the Commission to recommend a list of candidates for direct recruitment in order of preference. The Commission may hold such test or interview as may be considered necessary. The Commission shall furnish the government a list of candidates recommended by it in order of preference found suitable for direct recruitment. The number of candidates in each such a list may be approximately double the number of vacancy. Now, Lordship, may I pause for a moment? This double of the vacancy, this was abandoned due to coming of the FRBM rule, Lordship. The Commission shall simultaneously publish the list in the Assam Gazette and such order placed by the Commission as may be considered, Lordship. Okay, now, Lordship, in the present case, the government of Assam has given requisition to the APSC. Lordship, I have stated in my affidavit in opposition, Lordship, Annexure 1, Lordship. Page 60, Lordship.
Annexure 1.
Annexure 1, Lordship, page 60. With reference to such, I am directed to enclose herewith a copy of the draft advertisement for the post of Principal, Kukrajar Government College, Kukrajar, for advertisement and request you kindly to change that draft advertisement in the record, Lordship. So, according to that advertisement, that Annexure 1 in the writ petition, Lordship, the advertisement was issued, Lordship. Regarding the my learned friend has only 3 issues in the pleaded. First, the selection committee has not been considered as per UGC regulation, Lordship.
Yes.
And second, that there was no ST or SC member.
No, first is that the committee.
Committee,
Election committee didn't have the ST member.
member.
third APSCO, which my understanding has abandoned now, that ground.
What you are saying, the second one?
Second one, that no ST or SC member, Lordship.
What is the first one? That is the first.
First one was the selection committee was not constituted as per UGC regulation.
Hmm.
And that committee, no ST or SC member, Lordship.
Hmm.
Third API ground, and one of the last,
API ground we are
no,
not missing.
and one of the other ground,
Is
that,
the distribution of marks.
yes, Lordship. Distribution ground has been developed in the argument stage, Lordship. The one another was period ground, that result of that selection was
Same day.
on the same day in a hurried manner, Lordship. Before going to distribution of mark, Lordship, may I try to address in another issue, Lordship? Lordship, I would like to draw page 30 of the writ petition, Lordship. Page 30, Lordship, rule, the UGC has dealt with the constitution of selection committee. Also got it. The selection committee for the post of college principal and professor shall have the following composition. One, chairperson of the governing body to be chairperson. Now, in the present case, Lordship, as I have pointed out that if selection is done as per Assam Education Service Rule, that there is no governing body of the government college, Lordship. So, in place of chairperson of the governing body, it should be done as per the as prescribed by the Service Rule of 1982, which should be the commission, Lordship. For a government college, there is no governing body, Lordship. So, following this regulation, the provision of selection committee has to be harmoniously be understood in terms of Assam Education Service Rule 1982. Now, two members of the governing body of the college to be nominated by the chairperson to whom? In the present case, Lordship, as the selection has been made by the commission, Lordship, this constitution will be as per the Assam Public Service Commission Procedure and Regulation of Business, Lordship, wherein the member has to be nominated. The member of the APSC will sit as a members of the selection committee.
Then
As per clause 5, which my learned friend has impressed, Lordship, trying to impress, and an academician representing SC, ST, OBC, minority community, able body, if any of the candidates representing this category of the applicant to be nominated by the Vice Chancellor, last sentence, if any of the above members of the selection committee does not belong to that category. Now, Lordship, in affidavit in my opposition, in paragraph 6, Lordship, I have given details who were the members of the selection committee. In my affidavit, apart from that chairman of the Assam Public Service Commission, one Srimati Jundri Sunwal and Honokanto Pegu, who were the ST member, were already in the selection committee.
just a minute.
(1982) rule does not prescribe who would be the member of the selection committee. It has divested the all power to the commission, Lordship.
Okay, yes.
So there is no apparent conflict between the UGC regulation and the Assam Public Service Regulation regarding constitution of the selection committee, as the entire selection was based as per the Assam Education Service Rule 1982, not as per the, it is a regular provincial college. It is a government college, principal of government college. It is a state Kedapur Assam Education Service Rule 1982 covered up field. And in case, in the, even in taking in the spirit of the selection committee of the UGC regulation, that 2 ST member is already there in the board. So if there is, if any of the above member of the selection committee does not belong to SC that category, then only 2 SC or ST members is to be coopted up from our side. As already there is 2 members, there is no illegality in composition of the board. Paragraph 30, that clause 5 last sentence is very much important. Selection committee and clause 5 lordship, last sentence. If any of the above members of the selection committee does not belong to that category. And lordship, third point lordship, that result was declared on the same day. Now clause C lordship of the same page 30 lordship, last paragraph. All the selection procedure of the selection committee shall be completed on that day, that is last day of the selection committee meeting itself, wherein minutes are recorded along with the scoring performer recommended made on that basis of merit, with a list of selection candidate and well-listed candidate panel name in order made shall signed by all members of selection committee. So what does the APSC committed the illegality in recommending the name on the same day? Lordship, we have experiences that earlier time, after conducting the interview, result was not published for more than a year, lordship. And result is known to all. Why this was kept pending? Various criminal case has been instituted before this board also, before the black trial is also going on. Nowadays, on that very day, if possible, the result has been declared by APSC by declaring in the website. It is only in order to reduce the malpractice in the selection process, lordship, not for any other means. And it is in compliance, it is squarely comply the provision of the UGC regulation also. So that ground, in my humble submission, lordship, does not hold any water. And third point, lordship, let me complete. Next, lordship, another my categorical submission before your lordship, the judgment in Banarshi, Bharatdas and others regarding the marking pattern to be adopted by APSC or UGC. My learned senior friend has hopefully failed to express that thing, that those judgments were in respect of assistant professor and professor, lordship. Here, lordship, we are conducting the selection of a principal. In UGC regulation, either in 2010, lordship, and in 2018, there is no provision, no marking pattern, how to assess and how to give the mark of assessment for a selection of principal. The 125 lordship, which my learned friend has shown before your lordship, it is not for principal, lordship. It is best known to him why he has shown it to your before your lordship. Yeah, there is no question.
Mr. Doctor,
Lordship.
you will have to also explain that judgment of Milo Justice Vaipei, the Bharatwaj matter.
Yes, sir. I have gone to lordship.
Because there the lordship has said that while making any selection by the APSC,
Lordship.
the UGC regulation shall prevail.
Yes, Lordship.
So within that
Lordship.
periphery, you have
Lordship,
to
Lordship.
clarify.
Lordship, that Bonasri Bharadwaj case, I am referring that my
That has to only with regard to the assistant professor.
assistant professor Lordship. In assistant professor Lordship, there is a specific marking criteria to be adopted by a selection committee.
So those two regulations prescribe the procedure for
Procedure,
assistant professor,
professor.
who are silent in regard
In
to post of principal.
post of principal Lordship. So in my humble submission, that Bonasri Bharadwaj case is not applicable in this present case to that aspect, Lordship. Here, the composition, the ground of challenge that the UGC regulation in assessing the merit of the candidate has not been followed. As per Bonasri Bharadwaj, it is mandatorily to be followed, Lordship. It is in respect of solely the assistant professor and others, Lordship, not for the principal. And there is a specific criteria in table 1, 2, 3, 4 of the appendix, how to assess the criteria of assistant professor and associate professor for shortlisting. In absence of any criteria in the UGC regulation, we are adopting the government guideline, Lordship, which is I have placing in the before record, Lordship. There is a guideline of government, Lordship, how to evaluate the merit of the candidate for the post of principal of a provincialized college. It is still being followed by the APSC for assessing the merit of the candidate for the post of principal. And Lordship, another important thing, Lordship, my and the selection committee, Lordship, has contained three expert, Lordship, which was nominated by the government of Assam Higher Education Department. That's Manoj Kumar Sharma,
This recommended
Lordship.
by APSC or as per the government, because 1982 rule is silent regarding who will be the selection committee.
The APSC, Lordship. As per Rule 6, it is the discretion of the commission how to constitute the to select the.
Is there any such provision in the APSC who shall be in the selection?
Yes, Lordship. The interview how to constitute the selection board, there is a provision in Assam Public Service Commission Conduct of Business Procedure 2019, Lordship. Listed, Lordship. Page 11. Lordship, Lordship, interview board.
Okay.
Lordship.
Yes.
Now, in case of Lordship, adoption of government guideline Lordship, we don't have the record Lordship. There is a selection criteria what which our APSC interview board has taken up for consideration for assessing the merit of those candidates is very much available Lordship. So I'm just pointing out Lordship. That's the question. There is a guideline of 2011 Lordship. Filling up the vacant post of principal of provincialized college and guideline for marking procedure for selection of principal in degree colleges. In 2011, that guideline was being followed in the present case also Lordship for assessing the merit of the candidate.
So still in force or it has been revived? Some other, it has been substituted by some new guidelines.
To my information, from we have taken instruction from APSC. The APSC is still following this guideline. Lordship.
Mr. Saikia, just hold on, Mr. K. Gogoi.
K. Gogoi.
Anything else?
Lordship, there is a printout before Lordship. On printed document I have placed before the
That
Lordship.
regulation.
Tabulation.
That regulation. Okay.
Yes, this tabulation is followed Lordship. Here, Lordship, here Lordship, will see there is some marking from the academic and also Lordship teaching experience, research and publication, administration, communication ability, ability to plan institutional program, ability to analyze the discuss matter, ability to analyze and discuss the research support, and ability to analyze the discuss the development Lordship. Because principal is a administrative post only, so this he was assessed in the under this parameters Lordship by the commission.
Relying on this chart.
List chart Lordship. Lordship would find every details in the record Lordship.
Okay.
This is my humble submission Lordship. There is no apparent conflict between the APSC and then UGC regulation Lordship.
Only one aspect of the matter. Your Lordship, can you see the advertisement is dated 3/11/21. That is at page 20. Then the corrigendum is there at 15/6/22.
Page 24, yes.
15/6. So advertisement is more or less on 15/6/22. Now that regulation, your Lordship will can say that 21 regulation 4F.
21 regulation talking about.
That is dated 4/12/21.
19.
Well, I have given a
Which page?
printed your lordship is it?
21 regulation.
Yes. This one?
21 regulation is not available.
19.
The 19 regulation was adopted in December 2021. That regulation.
No, there is an amendment.
What this regulation talking about?
Yes. Not this one.
The white one.
21. Well, yes. That 4F, your lordship, can you see?
Page.
4F.
Yes. Yes, 4F we have seen.
4F. For
For
selection of teaching faculties, non-teaching, technical of government colleges, the selection of teaching faculties, non-technical librarians of government colleges will be as per UGC guidelines, regulations, with modifications where necessary as may be decided by the commission. The final assessment recommendations of candidates will be based on academic score records and interview performance in the ratio of 75-25. This is not there as per this regulation also. They are to follow UGC regulation. There is no guidelines from the government of Assam or by the government of Assam that UGC regulations will not follow. The relative weightage to be given to criteria such as academic performance, research, work, teaching experience, etc. for the academic assessment and shortlisting of candidates will be as per the UGC guidelines with modification where necessary as may be decided by the commission. Where is the thing, my lord? That we will not follow this regulation. The number of candidates to be shortlisted and called for interview shall be so and so. The recommended selection list will be forwarded to the government by the Secretary, Principal Controller of the school. So that UGC regulations, their rules itself. But as per the UGC rules, my lord, regulations, they cannot neglect these regulations.
Okay.
Unless the government says so. Government has given one corrigendum, I find. The research work will not be, that even that office memorandum issued by the principal secretary, page 25 as a association manner. Guidelines for selections of principal in provincialized colleges.
That's right.
Below I have shown, my lord, now the UGC by regulation data so and so has modified the eligibility criteria for the post of principal of provincialization colleges as shown below, so and so. So this office memorandum issued as per UGC regulation. So for all purpose, government also follows UGC regulation. They cannot override this. And Justice Bypass decision has elaborately discussed all this matter. Luckily, my lord, 21, my lord, they have brought this, will follow UGC regulation, but marking pattern 25% will be in my hands.
So that this modification was done as per Bypass judgment as per our opinion.
I don't know, at that time he was not there. Not a colleague.
For your information.
Lordships,
During the document,
Lordships. Regarding Lordship, the 9/12/2011 Lordship, that particular
we don't have. First page we don't have.
particular guidelines Lordship,
What Mr. Datta has given is this
Lordship,
first page is not there.
Lordship.
So
Here in the
we don't have the first page here, but of course we have the
Lordship,
criteria.
it is here. This here. Lordships, that was still followed. That was as per UGC regulation 6.9.0 Lordship. As per UGC regulation 6.9.0 Lordship.
This This is 2010.
2010 regulation, Lordship. And it was issued 2011, Lordship, and that is still in valid, Lordship, is still in force, Lordship. That was. As per 6.9.0, Lordship, that was stipulated how to marks should be given in respect of the candidate for principals, Lordship. Regarding API school also there, Lordship. And that particular selection was also made, Lordship, on the basis of the Lordship statutory provision of 1982 rules, Lordship, where it provides the FPSC is the authority to conduct the selection process in respect of the principal of the government college, Lordship. And there is no conflict between the UGC's regulations and the 1982 rules, Lordship. Even, Lordship, FPSC's that procedures for, Lordship, selection, Lordship. And that guidelines was on the consonant to the UGC's regulations 2010, Lordship. Regarding calculation of the marks of API, Lordship, and it is also exactly similar line 2016 regulation also, 18 regulations also, Lordship. Not a single word is changed by the University Grants Commission, Lordship. API scope question. And regarding, Lordship, distribution of marks, nowhere UGC regulation stipulates the provisions but criteria in respect of, Lordship, distribution of marks in respect of principals, Lordship. UGC regulation only stipulates the, Lordship, in respect to assistant professor regarding shortlisting. Even then, UGC regulation also not prescribe the procedure for, Lordship, selection also, Lordship. Assistant professors also, Lordship.
Now, Mr. Gogoi,
Lordship.
earlier used to place few judgments
Lordship.
where the apex court has laid down the law
Lordship.
that while selecting any such assistant professor or
Lordship.
professor, it is mandatory on the part of the authorities to comply with.
Lordship, Kolani Mathivaran, the law is laid down by the Kolani Mathivaran, Lordship, paragraph 60, the Kolani Mathivaran states that unless and until adopted by the state government, Lordship, it is the direct way, Lordship. Even, Lordship, the required minimum qualification we cannot dilute, Lordship. The minimum required qualification prescribed by the UGC cannot dilute, Lordship. It was followed by the Government of Assam, Lordship, as per section 7C of the 2010
There is
Lordship.
a particular judgment that specification for those posts,
Lordship.
right?
Lordship.
It has to be in terms of the UGC.
UGC regulations, Lordship, in respect of minimum qualification, we cannot dilute, Lordship. It is recited by the apex court from Annamala University till today, Lordship.
So the qualification prescribed by the UGC has to be followed.
It has to be followed, Lord.
And there cannot be any
there
such
cannot be, Lordship,
relaxation of any such.
Lordship.
Eligibility.
Recently, one judgment came from the Honorable Kerala High Court day before yesterday. They have said that they also similar view was taken by the Honorable Kerala High Court. Kerala High Court says that, Lordship, we can enhance the qualification criteria prescribed by the UGC, Lordship, but we cannot dilute, Lordship. The authority of the state can enhance it, Lordship. The authority of state cannot derogate it, Lordship. And that aspect was followed by the Government of Assam also, Lordship. As per Rule 7.6, it is stipulated that the norms prescribed by the UGC, Lordship.
Which judgment you are saying that it needs to be adopted by the states?
And it is
Not Annamalai.
no, it is, Lordship, Kolani Mathivaran, Lordship, 2015, Lordship. I will give the citation, Lordship. Asana? Kolani Mathivaran.
Give us the citation.
2015
6 SCC.
2015 6 SCC
360, Lordship. Here, Lordship, relevant person is, Lordship, 62.4, Lordship.
Under the 22 Supreme Court, para 4 it is discussed.
That online judgment.
22 Supreme Court Gambhir judgment, Lordship, in respect of state of Gujarat, Lordship. The issue is there, Lordship. The state of Gujarat has already adopted the 2010 regulations, Lordship. That's why that particular Gambhir judgment came up before from the Honorable Apex Court that as the state of Gujarat has adopted the UGC regulation 2010, so it's binding and it's mandatory to the state of Gujarat, Lordship. They never deviated from the findings
What is
of
that
the
judgment?
Lordship.
The Gujarat judgment.
That is Gambhir judgment, 2022 judgment, which was relied by my senior sir. It's probably Gambhir judgment, Lordship.
This is not.
It's that from Kerala lordship, that was in the Kerala to listen even. Srish Kumar to listen.
Latest 22 this week.
Rajashri MS.
Oh.
Rajashri MS, Professor Sisnar is from Kerala lordship. Originally it's from state Kerala, Honorable Kerala High Court
Are
lordship.
you telling about this particular judgment, Rajashri MS?
Rajashri MS, it is from the Kerala High Court. Before their lordship, one judgment was authored by my Lord Justice M.R. Shah lordship. It was also authored by M.R. Shah.
Gujarat judgment we are talking about.
Gujarat judgment also, that is M.R. Shah lordship. Gambhir Dhan lordship.
Do you have the,
Gambhir Dhan, I will give the citation lordship.
give the party's name, we'll find.
Lordship. Gambhir Dhan K. Gadvi lordship.
Okay. File over.
2022 5 SCC 179 lordship.
2000,
22 5 SCC 179. This judgment was passed on the ground that lordship, that particular IUC regulation was adopted by the state of Gujarat lordship, so it is binding. And in respect of the Professor Sisna's case also lordship. In this case, the state of Kerala has adopted the IUC regulation 2010. So Honorable Court's finding is that as and when 2010 regulation is adopted, it is automatically adopted the clarificated regulation 2016 of the IUC lordship. That is the finding of the Honorable Apex Court. But Honorable Apex Court nowhere deviated from the findings of the Kalyani Mathivanan case lordship. Kalyani Mathivanan, the law was laid down by the Kalyani Mathivanan, is still holding the field lordship. Unless and until state adopted, it is the directory, and if it is adopted by the state, it is mandatory. 62.4 lordship. The findings of the Honorable Apex Court 62.4 in Kalyani Mathivanan case lordship. It is still in the field lordship, hold in the field lordship.
but Mr. Gogoi,
Lordship.
if I'm not wrong,
Lordship.
if I'm not wrong, just recollecting,
Lordship.
when the government decided to pay UGC scale of pay,
Lordship. Lordship.
they, through the finance department,
Lordship. Lordship.
government adopted UGC as well as the AICT norm.
Lordship. Lordship. That part, lordship, we have not deviated.
That's what I'm just thinking.
That part we have not
That
debated,
norms
lordship. Norms,
That, I just, that's what you're going to do, that it is for the qualification or for the purpose of,
for UGC and AICT scale of pay lordship, it is for qualification purpose. If any persons, any lecturers who have fulfilled the required qualification prescribed by the UGC and AICT lordship is entitled for the UGC scale or AICT scale lordship. In respect of technical lordship, they will get the AICT scales, and in respect of non-technical persons from the engineering institute also, they will get the UGC scale lordship. Otherwise, in the college, they will get the UGC scales.
thank you, Mr. Gogoi.
In respect of lordship, that
Thank you.
purpose.
Thank you. This will help us.
Lordship. Oblige, lordship.
My lord, only one aspect that Srijit case, my lord, that 2022. State was saying, my lord, because the single judge and division judge dismissed the case on the ground, the state government has got different criteria. Because they did not send the panel of 3 names. So ultimately, my lord, the Supreme Court said no. As per the UGC regulation, you are required to send 3 names. Having not sent that,
It's not a panel.
My
It's a
lord,
single.
not a
That
panel.
I'm aware of.
This is what. So, my lord, my submission made by my learned friend that the Kalyani Mathivan case has been, my lord, still, my lord, in force. That is not correct, my lord. It has been distinguished. It has not been accepted by the division bench by the latest judgment.
Look into it.
Oblige.
I appear for the private response number
Yes,
6.
you have
my lord.
to, you have to say anything.
My lord, just 2 aspects regarding maintainability, my lord, and how the matter is premature in nature. Now, the learned Advocate General and my learned friend representing the APSC has already satisfied your lordship over the aspect that the members of the selection committee, it constituted persons of the reserve category, and also they were recommended by the government, my lord, and that can be ascertained from the records, my lord. Now the petitioner has challenged the constitution of the committee, my lord. Over that aspect, only one case law I'd like to place before your lordship. That is
You are
already
raising the maintainability.
yes, my lord. Only 2 points regarding maintenance. First is regarding the constitution of the selection committee and how that cannot be challenged once he has participated in the selection process. That I have already, the judgment is already reproduced in my affidavit. Your lordship will kindly come to page 67. Affidavit in opposition filed by the respondent number 6. Page 67.
Om Prakash Shukla.
This is Madan Lal versus State of Jammu and Kashmir, my lord. 1995, 3 SCC 486. Starts from page 67.
1995, whole case, I remember the mother.
Yes. 1995, 3 SCC.
Your affidavit in opposition filed on December 2022,
Yes, yes,
right?
yes.
Which
8th of
para you have
December.
said? 1995, 3 SCC 486.
Yes, ma'am.
Hmm.
Paragraph 3.1. My lord, paragraphs I'm relying on is para 9 and 10. That is already reproduced, my lord, from page 68 onwards. If I may read, my lord.
Not required to do.
Now, my lord,
This is one you are relying on.
yes, ma'am.
This is with regard to maintainability.
Yes, ma'am. And secondly, my lord, your lordship has already seen rule 5 and 6 of the 1982 rules, my lord, which says that direct recruitment to the post shall be made by the government on the recommendation made by the commission, my lord. Now, the government is yet to act on the recommendation made by the selection committee, which the recommendation is at page 27 of the writ petition, my lord. Pursuant to that recommendation, recommending the petitioner and my name. Now, pursuant to that recommendation, the lordship will kindly see their representation before the executive, raising the grievance. That is at page 43. Page 43 is their representation raising their grievance before the executive, dated 9/11/2022. Now, the judiciary is the last resort, my lord. A person has to come to the judiciary once the executive fails to take any decision. A writ is to be issued by the judiciary over any inaction of the government, my lord. Now, this is of 9th of November 2022. Your lordship will see the affidavit of the petitioner in the writ petition on the same date, my lord. On the very same day, she comes to the court. She goes to the office of the Director of Higher Education, files the representation, comes to the High Court, swears before the notary, and files his petition. Where is the time, where is the chance given to the executive to come to a decision? Perhaps the executive could have taken a decision in her favor against me. That is all, my lord. It is completely premature, and so it should be dismissed by allowing the government to take a decision, my lord. I am not saying that you give the post to me, my lord, in my favor. I'm saying that the government should be given a chance to take a decision. And your lordship has passed an order. This is regarding Bengali High School, post of principal in Bengali High Secondary School, Paltan Bazar, Guwahati. I'm placing this.
Referring back the matter to the government.
Yes, ma'am.
Director, right?
My lord has set aside the interim order, vacated the interim order, dismissed the case, and recommended the, sorry, my lord, it has referred the matter to the government. Anuradha Das Patra versus the state of Assam. This is order dated 24/6/2019. WPC 1737 of 2019. If I may place a copy. This is my limited submission.
Mr. Bharatwaj, show us from the Rule 6 of the 1982 rule. That any such recommendation to be made by the appeal that shall be acted upon by the government or after some deliberation. Is there any such provision?
My My lord, the very first line, my lord, direct recruitment to the post mentioned in sub-rule 1 of Rule 5 shall be made by the government, my lord, on the basis of recommendation made by the commission. Well, that itself
That's
is
fine.
yes.
On the recommendation of the commission.
Yes, my lord.
Now, please come to
Rule E, my lord, sub-rule E.
6.
Yes, ma'am. Even though the sub-rule elaborates the procedure, my lord, but the principal subclause 1, my lord, of 6, principal clause says that the government is to act on the recommendation. And the APSC, I mean, the commission is to make public the recommendation that has been made.
Rule 6, Rule 6A or Rule 6 what? Which one is like?
My lord, Rule 6(1), my lord, government on the basis of the recommendation made by the commission. It is followed up by the sub-rules A to E.
That is why I'm asking you to read it.
My lord, the commission shall simultaneously publish the list in the Assam Gazette and such other place as the commission may consider proper. My lord, this is, so far as my knowledge is concerned, my lord, is regarding the recommendation, my lord, which has been made at page
So once the
27.
APSC makes a recommendation, why not an aggrieved candidate may file a writ petition?
Because the procedure is not over, my lord. Because the procedure is for the government to issue the appointment letter, my lord.
Now, you want to say that any such party will proceed only when he is or she is aggrieved.
Yes.
But right accrues when? From
My lord,
selection,
on
not on appointment.
my lord, selection and appointment in some other matters, my lord. In certain, yesterday I went through a decision of the division bench in a Gaon Pradhan case, my lord. My lord, there also the executive rule says that on appointment, my lord. However, the division bench clarified it. It said that selection and appointment, both words are to be read together, my lord.
Exactly.
So once I'm appointed, my lord, only then
So
the
tell
selection
us-
process will be completed.
You'll get a judgment from Honorable Justice U. Bhuiyan, where it is decided that the right has only from the date of appointment on such recommendation of appointment by the government. That's a matter relating to, it's a reported judgment in this JLP. On lady petitioner was there, but the matter was referred back to the Director of Higher Education to redo the exercise, directing the petitioner, considering that the petition is premature because the matter is pending before the Director of Higher Education regarding selection of an assistant professor or principal, whatever, to the provincialized college. So only when such appointment is to be given. Appointment is to be given by the Director of the Higher Education. Then the right will accrue on the part of the petition. So before that, he or she can apply whatever grievances is there before the authority for consider. So that stage the matter is pending before the Director. So the matter petition is premature. It is for it's a lady petitioner, but it's a reported judgment where his lordship has said that his right will accrue only when the appointment order is given. Right?
Yes.
That is where appointment is concerned.
Yes.
Now you are saying that both selection and appointment goes together. So when the right will accrue?
Well, the right will accrue, my lord, she has a cause of action on the day of my appointment, my lord. On the day the appointment order is made. And my lord, there's a difference between appointment and joining, my lord. There's a period between that also when she can come and get a stay order. But not now. Not at this stage.
Okay.
Lordship, another recent judgment on naval apex is also there. I have given the mail, Lordship. Paragraph 20, Lordship.
Have it.
Paragraph 20, Lordship.
Look into it. Yes, Mr. Das, anything to reply?
I think Mr. Gogoi was referring to Gujarat case. This is 2022 5 SCC 179. It says 2000 because Gujarat has adopted UGC regulation. Assam has also accepted UGC regulation. Therefore, the college principals and college teachers are getting UGC pays. So therefore, my lord, as per the UGC regulation 2022 5 SCC 179, that Gujarat case, paragraph 28 and 29. 22 5 SCC 179.
Yes.
Paragraph 28 and 29. Here the court said even 2018 regulations, UGC regulation is to be adopted. Regulation is not for the purpose of only, my lord, pay.
Qualification
Yes,
or pay.
not for qualification. They will have to follow the procedure also. It has been thoughtfully made, man. I'm deeply obliged, man.
Lordship, in this case, paragraph 20, Lordship, I have given already. Paragraph 20.
Deeply, man.
Immediately after all this affairs over, because we have to see this. Because along with this, another university matter is pending, which is of similar nature. That's why there I have made it half written, because to look into the other things here. BD does learned senior counsel. Yes, is that by Miss Dekar? Who? So, D. Segal, and Advocate General Assam, assisted by Mr. K. Gogoi. Also for and Mr. S. R. Rama for the respondent numbers 1.
3.00, 4.00, 4.01. আমি তিনটা প্রস্তাব আমার
7, 8. Mr. P. B. Dotto, Standing Council Public Assam Public Service Commission for the respondent number 2.
4 and 5.
4,
2, 3, 4 and 5.
2 to 5.
2 to 5.
And Mr. P. Bharadwaj, right? For the respondent. I mean, either before Bihu or immediately after Bihu. We'll see to that. We'll give the date. Not necessary. Yeah.
Another office memorandum, your lordship may kindly note, my lord.
Yes, definitely.
Dated 24. Can I give it, my lord?
Just give it, we'll note it down.
My lord. Government's notification dated. What I will. 22. Dated 24/1/22. Office memorandum issued by Higher Education.
24/1/22. Okay.
It says expert that SCST.
Okay.
Marking patterns are also given.
Sure.
I'll give a print, my lord, to your lordship.
We'll get it, no problem. Okay, if you have a copy, it doesn't matter. You just forward it to him, we'll get it out.
Deeply obliged.
Hello. Ready. In 2010 regulation, so 2010 regulation. This is 2010. এখানে একটা ই করে করে not a component, second dictation দিতে হতে যাইতো সেকেন্ড ফলোর উপর diagram. 1 2
I can xerox the.
No, not required. 2010 regulation, we have already noted down somewhere, it is there, but the server has done it. I like it. After email.
এখন রাখা থাকি যাব না আমার রাখি তো item number 2 morning lordship they have said that senior
Yes,
SRS
yes,
already are some medical
Yes, yes. So we are not checking up. We'll
so
just
lordship
give
may
it.
fix any other day lordship
We'll just find out.
and as per my lord's direction we have deposited the all the records lordship records already there lordship border record kini ase both the records from secretariat as well as directorate lordship we have professor Bando এখন আহা মত তুমি গিয়ে আমাকে মারতে সোয়াই না মত এই অবজারভেশন দিছিলে যে মন সাইনমন্টৰ 500 অবজারভেশন দিছিলে
This summit is about that Mr. H.R. Chaudhary and its concept. Last 40. Place this method on. Two zero 28th of April.
28th of lordship
Yes.
After 23rd Lordship, I have some difficulties after 23rd Lordship. 24th Lordship, I have no problem. 24th.
24th is a holiday. So we'll have it on 25th.
Lordship. Lordship, just academic Lordship. In the earlier cases, Lordship, before passing of the Sisnath order by the Honorable Apex Court final order, Lordship, when notice was issued, Lordship, that order, Lordship, may kindly go. It is an interesting order passed by the Honorable Apex Court, Lordship.
Is there in the judgment?
There, not probably in the website, I will provide, Lordship. Honorable Apex Court observation, Lordship, may kindly go to it. What Honorable Court observed, Lordship, in regarding Gambhidon case was observed by the another bench, Lordship. Another bench observed that that particular judgment, Kalyani motivation was not discussed, Lordship. So only notice was issued, stay order was not granted, Lordship. After that, Lordship, that particular Sisnath case was came before that particular bench which was passed the Gambhidon judgment, then they have passed that judgment, Lordship. My Lord, may kindly go to the notice issued order of the Honorable Apex Court. It is a very
Go to the
interesting.
website and find out.
A very interesting, Lordship. How Honorable Court dealt with that, Lordship.
Thank you, Mr. Gupta.
Lordship. Oblige, Lordship.
Yes, Mr. Burua.
May I please, Lordship? This issue is basically, my lord, this petitioner was a founder teacher, this is Bhansar School, 92 is appointed. And he was regularized by provincialized to 1/1/2013, my lord. Now he is the senior most. Now he was given the in charge. But that was cancelled, my lord, on the objection filed by the ME school teachers who is amalgamated with the high school, Tengapara High School, in the year 2017. So that is why we are have approached this honorable court. My lord, may I
Just a
leave?
minute, just a minute. Have you annexed the amalgamation
Yes, my lord,
terms
amalgamation.
and conditions?
Yes, my lord.
Now,
Page 44 is the seniority list, my lord.
no.
Page 44,
Amalgamation order is at page 38.
38, my lord.
Now
And
just show us the name of the petitioner and the respondent.
yes, petitioner is 2. Tengapara High School, serial number 2, Ramakrishna Burman. And my lord, in ME school, he is the bottom seniority, just before this Chokidar, Subrato Chakraborty. Therefore, just it is because he has transferred in 2015 from another school. He lost his seniority, and new ME school, he was given the bottom seniority. Now he want to be the headmaster, and his objection is entertained. My lord, may I lord, point your lordship page 44, my lord. This is the seniority list by as well as headmaster.
Just a minute. Where is the complaint lodged by the respondent, private respondent?
This was not with me, but I have replied. Page 46, my lord. I have explained everything. Why should I give him the seniority and why should I give
You are
him the-
agreed by the order of 24th of December.
Yes, my lord.
Prior to that, this 11 December,
This decision was taken, my lord.
just a minute. Okay, we'll come back at 2.
Input number 1, I have one message.
UBDA, no problem. If there is something else, we'll call it, we'll pass the order only in your presence.
They have filed the affidavit.
Look at Please take your Who is for Mr. Sisti? Do you have the book with you?
Yes.
It's 41.
Yes, Your Lordship.
Rule 24.
Yes, seniority.
Turn to the next page. Sub-rule 5.
Sub-rule 5. In case of amalgamation of ME, MV, LP school with other higher secondary school, high school under the scheme 6, etc., the employees of the amalgamated school shall be given seniority with effect from the date of joining on substantive appointment or regulation. Provided that in case of graduate teachers, the seniority shall be counted from the date of getting salaries meant for a graduate teacher. Provided further that in case of contractual teachers, the seniority shall be counted from date of absorption in the sanctioned post carrying regular time scale of pay.
Now, it is verified
Yes.
that if A is the high school or whatever,
Yes.
and B is the ME school,
Yes.
and B is amalgamated with the A school,
Yes.
then seniority with effect from the date of joining on substantive post
Substantive
appointment,
or
substantive appointment regulation. So any teacher
Yes.
who has been appointed in the substantive post in the B school,
yes, no.
he or she will get the seniority from that date.
Yes.
Proviso is that in case of graduate teacher,
Teachers seniority shall be counted from the
from
date
the
of
date
getting.
of getting salary is meant for a graduate teacher.
Yes, sir.
And in case of contractual teacher, seniority shall be counted from the date of absorption in the sanction.
Yes.
Now, under this provision, please come to rule 2 and 2 I, page number 21.
Yes. 2 and
I, page 21.
graduate teacher means and includes the category of assistant teacher, classical teacher of high secondary or senior secondary, arts junior college or high madrasa or high school, including amalgamated higher secondary and senior secondary and high schools, for whose appointment the minimum qualification is graduate in arts, science, commerce from recognized university, including demonstrators of a provincialized higher secondary school or a senior secondary school.
It doesn't say about any such graduate teacher in ME school,
Yes, sir.
including amalgamated higher secondary, secondary and high schools for whose appointment.
The minimum qualification is graduate in arts, science, and commerce.
Here the consideration was amalgamation is there,
Yes,
but
sir.
did not say anything about
ME.
ME. So those who are graduate teachers.
Yes, sir.
Now here the respondent is serving as an assistant teacher in a ME school.
Yeah.
He was receiving graduate scale of pay.
Yes.
Can he be considered as a graduate teacher? Because definition of graduate teacher doesn't include any such,
MEs, yes, Lordship.
doesn't include any such teacher serving in a ME school,
ME school.
receiving graduate scale of pay. It is not there. Only thing is that in a amalgamation where the minimum qualification is graduate.
Yes. In that case, if the amalgamated school is a ME school, Lordship, if he is a graduate, Lordship.
Even if a graduate, because has to be pay scale is there, whose qualification appointment condition is that he has to be a graduate.
Yes, Lord.
He may be a graduate, but may not be, his requirement is may not be a graduation.
Is a graduate scale. Yes.
Where, if you read that one, you will see that it is
Provided that case of graduate teachers, seniority shall be counted for date of getting salaries meant for graduate.
it is only for graduate teacher.
Yes, Lordship.
Here the question of other teachers are not mentioned.
Yes, Lord.
In a ME school, there is no question of a graduate teacher.
No question. BTC every definition की लिखता है
Mr. Islam, show us the original one, this graduation pass certificate.
Graduation pass certificate.
Mark sheet, whatever is there.
Page 33, 34.
Original one.
Original perhaps may not be available. He sends scans copy only. That was a COVID time.
Please come to page number 33 of your affidavit.
33.
Annexure 1.
Yes.
It was issued on 1993.
He issued on, but I passed earlier. That's
You don't know.
That's
Why the university will give you a pass certificate of 1993?
my lord.
That is where to see the original one.
I can produce. I can produce. No. Some other day I can produce. Let
You
him
have a
come.
copy.
Originally is not with me. That time was COVID period. He sent scan copy only. That is the whole
You don't have
difference.
a mark sheet.
Everything. Marksheet also. Yes. But my initial appointment was on graduate scale of pay. That is page 35.
That is there, but it's the rule doesn't prescribe anything like that.
So, from the date of receiving graduate scale of pay. Graduate scale of pay, I received in 1992, whereas petitioner received on 1/1/2013. I have annexed to the Department of Secondary Education giving identity card, page 61 and 62. Date of joining, Pran Krishna Burman 1/1/2013, and my date of joining 9/6/1992. I will argue at length. Whether I am a graduate teacher or not, I'll forget. Science graduate teacher, page 33,
Where is the
37, my lord.
advertisement? On what basis you have been appointed on ad hoc basis?
Ad hoc, initial appointment was on ad hoc basis against sanction post. But my lord, that
Any
point
selection?
I am not after selection.
Where is that?
On ad hoc basis to act as science teacher. That seniority I will lose. I will get my seniority only from 1996. My initial appointed temporarily on ad hoc basis to act as science teacher at Noagaon ME School in the pay scale of so and so, plus other allowances as admissible under rules with effect from the date of his joining in the school, district elementary education officer. That time it was from 1996 onwards, ad hoc appointments are there. But I am not claiming seniority. That my post was regularized by Annexure 4, page 37, my lord. In the interest of public service, the appointment of Shri Chaubrata Chakravarti, science graduate teacher, who was appointed on ad hoc basis in Noagaon ME School 5 DO, Kokrajhar order number so and so is hereby regularized.
Where is next page of 50? There is in between, there is a page
50,
50 and 51 of your affidavit.
50 and 51, that amalgamation order,
There is, has to be one more page. Where is that page?
50 and 51.
In between, there is a page.
If there is some more page in between 50 and 51, I will have to check it. Other side has also given this. Sam, 50. One page is different, okay? It is same. Petitioner side has also given.
There has to be a third page.
It is same. There is 38, 39.
Mr. Sisti? Normally, when these schools are amalgamated, the conditions are incorporated in the next page. Right?
This is no commissioner.
What is missing is the grade 4 employee of the LP school.
Yes.
You should the list of persons serving in the LP school is clear.
Yes.
But the grade 4 employee is missing.
Yes. Yes, one page is missing. LP school page for it.
There has to be a third page.
Yes, sir.
Mr. Burra, do you have an original copy?
Original copy too. Don't think, my lord. Original copy.
Burra, the more tabular folder to select plastic folder. Mr. Borua, well, after 2020, not 2018 rules. Have the 2018 rules?
Yes, my lord.
Rule read 24, sub rule 3.
My lord. Yes, my lord.
Is 42.
In case of amalgamation.
Is number 42, rule 3, sub rule 3 of rule 24.
Yes, my lord.
Please read.
My page is 42, my lord.
42 only.
42.
Read.
Rule 3, in case of amalgamation of
No.
This in rule 3, sub rule 3.
sub rule 3.
Page 40.
Oh, yes. The seniority of member of service in a cadre who joins in a school otherwise than by direct recruitment, that is on transfer or otherwise, shall be determined as per the date of joining in the school in the concerned cadre. If member joins in the school through transfer from a school of other district, the seniority shall be determined from the date of his joining in the school in the concerned cadre, and the seniority of earlier school or the other district or in the same school in different cadre shall not be taken into account.
Now, from the affidavit filed by the respondent, it is clear that the petitioner joined the Tengapara LP school on his request.
On his own request.
So he
Here
was transferred.
from Chautara ME school, my lord,
But it is same district, my lord.
page 43 is
District, same district, it doesn't matter. In the school, if you read the provision, it's in the school. It is not
That
in the
part I will
provision.
argue.
page 43 of
With
this,
with the apex court judgment, I will argue that part. Whether rule prevails
my
or
lord,
general jurisprudence will prevail.
Now, after the school amalgamation, whether any such teacher who is posted in an ME school on his transfer, right? Can he jump over the other teachers of the ME school? Mr. Sisti, Ms. Bora, these are to be decided.
Yes.
Petitioner, way of his appointment without any selection and basis.
Yes, sir.
Appointed on ad hoc basis. Probably there is a judgment because this district elementary education officer is not the appointing authority of a graduate science graduate teacher in ME school. There is an order probably. There has to be old cases are there. It is only the director who can appoint, because if you see the old appointment orders of the science graduate teacher, it is by directors. There will be old cases. Maybe reported, maybe unreported. Not by DTU. Secondly, he was transferred in the case in hand, the private respondent was transferred at his own request. Maybe in the same district, it doesn't mean that he will gain this. But thing is this, in the same category. In the ME school, there is all this junior assistant teacher in the equivalent to a high school. So in the same category means in a cadre of, let us assume the graduate scale of pay. So the necessarily any such science teacher graduate scale of pay, he will come under the headmaster. Yes. Because it has to be in the same category, not the category. Now, on such amalgamation, whether such teachers who will transfer at your own request in a ME school can jump over the cadre of similar cadre. Yes. Because earlier, let us assume the private respondent here is in the cadre of graduate for the time. He came to this school on transfer on his own request. School has been amalgamated with the high school. He remained in the same cadre. Yes. Now, whether he can jump over the teachers of the other school, even if he's received graduate scale of pay, because he came, his transfer was not general transfer, it was on his request. Otherwise, then direct it. If it is transfer, fine, he will continue. But if it is on his request, then what will happen? Can he jump over the graduate teachers of the high school on being amalgamated? It is not only in the case of the petitioner, there will be some other teachers who might have received.
Yes.
Right? Whether he is, because both the schools become one.
Yes.
And the entity of this respondent will remain as he's a transfer teacher at his own request.
Yes.
Then what will happen?
It is transferred only he will lose his seniority.
So from the date of amalgamation,
Yes.
it has become one school,
Yes, sir.
one cadre. Cadre means junior teachers, senior assistant teachers, or classical teachers,
Yes.
right? Those are the cadres. So in that case, petitioner remains as a graduate teacher and becomes a graduate teacher, then will he jump over the other teachers of the high school?
I think he will not jump.
How he? Because his entity in this merged high school
Yes, sir.
becomes one.
Yes.
That doesn't mean that he will become a senior than the others. Had it been a normal transfer, which would have been different. Had it been a normal transfer, necessarily, because normal transfer. Yeah. But here, at the behest of the petitioner respondent, he was transferred.
Then he will lose his seniority.
Have to decide on.
Yes, sir.
Even if you read the graduate teacher, the word is very clear. Whose appointment is required is a graduate.
Yes.
Now, let us assume rightly or wrongly at this stage, petitioner was appointed as a science teacher with a graduate. We will see the certificates later on. But this needs to be answered by the government.
Part of employee is also and 20. আগত আছিল ওল্ড ৰুলত যিবিলাক 12-13 চনত কেছ হৈছিল।
Do you have the records with you? Give it to us.
Amalgamation of each new task transfer certificate. Ultimately, rule to interpret rule of care. One district to another district. Meaning to district of the कोई पता नहीं क्या at his own interest may be due to his mother's illness, but within the same district may the rule protect today will be taking general service general
J. Burwal, Council appearing for the see for the respondent numbers. 1 PO3. Also heard Mr. R. Islam and the Learned Council for the private respondent number 4 and Mr. SMT 60 standing council, Department of School Education for the respondent number 5. Matter relates to the in-charge headmaster of Tengapara High School, Pukrajak, under PTAT Assam, PTC Assam. The Tengapara Lower Primary School with the code 180105239 and Tengapara Middle English School with the code 18010523901 was amalgamated with Tengapara High School by an order dated 09/08/2017 issued by the Commissioner Secretary Government of Assam in the Secondary Education Department. Petitioner is a science assistant teacher science in say Tengapara High School, whereas the respondent number 6
4, my lord.
is an assistant teacher science. Was an assistant teacher science in Tengapara ME. Petitioner was appointed as an assistant teacher science in Tengapara High School during its pension stage, and said Tengapara High School was provincial. By the order number BC /SEC /118 BC. Please take your seats, Mr. Burwal, Mr. Islam. /2013/14 dated 21/08/2013. With effect from 01/01/2013. Under the provisions of the Assam Cancer Educational Institution within bracket Provincialization of Services Act 2011 as amended during its course. issued by the Director of Secondary Education. The as per the provisions of the scheme of Shiksha Kshetra, amalgamation and merger of schools, of different schools. With regard to the gradation list of an amalgamated school, this memorandum, provides that each of the teachers shall be the teacher of the higher school after amalgamation / merger, and their status will be revised. After amalgamation / merger, the gradation list of school as capital or district, as the case may be, has to be revised by incorporating the names of teachers against the higher school in accordance with his / her qualification and status. Also, he/she will get the seniority as before, and his / her name has to be placed in the appropriate place in such a way that he/she does not lose his / her seniority. Rule 24 within bracket 2. Rule 24 within bracket 5 of the Assam Secondary Education and Rule 24 of the Assam Secondary Education within bracket provincialized bracket schools rules 2018 relates to seniority, and sub rule 5 of Rule 24 of said 2018 rules provides as follows. Right. Rule 2 within bracket small I of said 2018 rules relates to graduate teacher. Tara got out of sentence. Rule প্রথমে rule লিখবা rule 24 লিখেছে না sub rule 3 of rule 24 provides as follows. তারপর sub rule 5 তারপর sub rule 2I defines graduate teacher in a secondary education provincial as 2018 rules, which stipulates category. From the affidavits, after such provincialization with effect from 1/1/2013, the petitioner received graduate scale of pay. With regard to the respondent, it is seen from the annexes appended by the respondent number 5 report that initially he was appointed on an ad hoc basis to act as a science teacher at Noagaon, NOW, Noagaon, NOWA, ME school, in the scale pay of rupees 1375 plus 3375 per month, plus other allowances admissible under the rules, with effect from date of his joining in the said school. Issued by the District Elementary Education Officer Kokrajhar of the wing father, that the post is originally created by the government under letter number EPC 567/91/109, dated 16/11/1990. Directing the petitioner to join within 15 days from the date of issuance of the said order by order dated 8/6/1990. The same district elementary education officer, now Bongaigaon, the district elementary officer Bongaigaon regularized the service of the petitioner.
Respondent, my lord. Respondent 4.
Sorry, that's one number 4. By the order dated 28/03/1994, was earlier appointed on ad hoc basis in Noagaon ME school. At his own request, the Director of Elementary Education Assam on 10/10/1996 transferred the petitioner to Choutara ME School under Kokrajhar district. Service of the respondent number 4 was confirmed by an order at Sotar Ali as a science teacher at Sotara ME School by order dated 21/09/2005 issued by the District Elementary Education Officer. As one Sri Susanta Nag, science teacher of Tengapara ME School, was promoted, the petitioner submitted application before the Director of Education etc. for his transfer to the said vacant post of science teacher in Tengapara ME School. The Director of Education BTC, on receipt of no objection certificate from the headmaster of Chautara ME School, by order dated 24/06/2015, transferred the petitioner and posted him at Tengapara, respondent number 4 at ME School against a vacant post of said Susanta Nag, science teacher, was promoted under the Deputy Inspector of Schools, Kokrajhar, with immediate effect. In the amalgamation order dated 09/08/2017, issued by the Commissioner Secretary Elementary Education, Assam, the petitioner was placed at the last amongst the teachers of Tengapara ME School.
Respondent.
After the amalgamation of Tengapara LP School, Tengapara ME School with the Tengapara High School, it has become one amalgamated Tengapara High School. The respondent authorities number 3 and 6 not 3, 1 and 6, 1 and 5, by filing the respective affidavits, shall clarify their stand as to whether the respondent number 4, who was transferred to Tengapara ME School at his own request, shall I have to go, I've been called by. Yes. To complete, it will ask the authorities to submit their additional affidavits. Yes.
Respondent.